Okay, we have Mr. Tinker and Mr. Wasson.
Good morning, Your Honor.
Morning. Mr. Wasson, you are here for the appellant. Do you wish to reserve any time?
Yes, Your Honor, I'd like to reserve 5 minutes for rebuttal, please.
You got it. Go ahead, sir.
Good morning, Your Honors. I'm Roy Wasson, counsel for the appellant. This is an appeal from an order granting a new trial in a personal injury case based upon a single isolated reference to the plaintiff's own health insurance by my trial counsel at the trial court level. It's, as I said, a single isolated reference that applied the wrong standard. The trial judge here clearly thought that it was a per se new trial or mistrial, which I'll get to the issue of whether it's a new trial or a new trial in a few minutes, if that's all right. But the court obviously applied the wrong standard, just saying immediately, "Oh, this is bad. This is a mistrial." Not familiar with the appropriate standard. And the standard, of course, as cited in many cases in our brief, is that although courts do not permit parties to intentionally or knowingly interject liability insurance into a case, even a reference to liability insurance, if it's isolated and if it's cured by a curative instruction, does not warrant mistrial. So the court applied the wrong standard. South Motor Company versus Accountable Construction case, the first one that I cited on page 36 of our brief, says that you've got to look at the whole issue here. And the thing that makes this the most unusual is that the first reference to insurance in this case, which was not the subject of any objection, any curative instruction or anything, was the reference by the defense CME doctor, Dr. Mirabello, who was being asked about, whether he treats more patients or testifies in a medical legal perspective. And he said, "Hey,
Mr. Wasson, and we're familiar with the record on that. And so what is the explanation for your waiver argument from the other side? How do they explain that away, that they didn't raise the objection when the first opportunity arose?
I'm sorry, Your Honor. I'm not prepared to make the other side's argument for them, and
I mean, certainly you would know what their argument is, so what your reply to that would be, right? Because I'm not really sure I saw one from their argument, and I was curious if perhaps I missed something from the record, what the response to that is.
I'm sorry, I made the waiver argument that by not saying, "Hey, we shouldn't put insurance in this case," on Dr. Mirabello's reference to, obviously, to liability insurance paying for his fees, then how could counsel complain about a single isolated reference, not even evidence, but a reference in an argument to whether or not the plaintiff had health insurance? So I'm sorry if I don't understand the court's question, but
maybe poorly given to you. I just was curious, how do they respond to that? How do they respond to your waiver argument?
I'm sorry, I'm not prepared to answer that.
Okay.
Let me ask you something, Mr. Wasson. If we accept your characterization that the mention of insurance here was indeed fleeting and insignificant, have you found any case where an appellate court reversed the granting of a motion for new trial or mistrial? Because the cases that I've read in your brief, they all seem to arise either on evidentiary errors that require new trials, or they are reversals of the denial of a motion for mistrial. And I don't have to tell you, as I'm sure you're aware, that the already generous discretion that we are supposed to afford trial judges gets heightened even more when it's a grant of a mistrial. So help me out with that. Is there a case that says that?
I wish I had, and I started looking again this morning. I didn't find any such case, but the language is so clear in these cases that the language of these cases that affirm the denial of new trial make it clear that it would be an abuse of discretion where there is no showing of any prejudice. And the thing about appellee's brief here, Mr. Tinker does not suggest how they might have been prejudiced by a reference to my client's health insurance as far
Well,
as
I'll wear Mr. Tinker's hat just for the sake of argument for 1 second. I think if I read the brief correctly, what the argument was is not just, it is not just the mention of insurance in a vacuum, but rather the fact that the way the question was worded, basically not all of us have health insurance, or those of us who have a health insurance may not appreciate this. The inference that one draws from that is that this poor person doesn't have health insurance. Pity them.
I didn't get that from the context of the trial. I thought that the question about
Well, and that kind of illustrates the point, though, is that we're here on review. The trial judge was there at trial, heard the inflection, heard the words, saw whether or if at all it impacted the jury, and made the call and granted the motion for. I know there's some, for whatever reason, there's some dispute about whether it was a motion for mistrial, motion for new trial, whatever. Granted the motion, and we're supposed to be very deferential to that. So help me out without transporting us back in time to that magic moment. Help me out. Why was this just such a gross abuse of discretion, given that the trial judge was there in real time?
Granted the motion because the court applied the incorrect standard, because the court thought it was automatic per se reversible error, Your Honor. It's pretty clear from the transcript, in my opinion. Very good case, just filed. Notice of supplemental authority came out in June from the first district, Winters versus Harper. I wish it was the case that we're looking for, that was reversing the grant of a trial, but with all the cases cited in here, it says, it establishes that unless there is some prejudice that cannot be cured by a curative instruction, we don't want to go putting trial courts back to trying expensive cases with many experts and treating doctors and so forth, based upon something that could not possibly have affected the outcome of it. And I direct the court to the Winters case and the many cases.
Once again, on the Winters case, as Judge Lucas was pointing out, that's a case where the trial judge did not grant the new trial.
Right.
They looked at these facts and said, even this is not enough, and it is quite different. I mean, here we have the attorney making the insurance statement in a compelling manner to try to ask the jury, put yourself into the position of people. We have health insurance, I think, how he states it. That's different than the statements in Winters. So getting back to Judge Lucas's question, you don't have any cases where they've said a trial judge was so far out of the realm of reasonableness to grant a mistrial or a new trial, as opposed to not granting it based on a couple times where insurance was used in some of these cases.
I do not, but it's just a fundamental principle of appellate practice that in the absence of prejudice that could have affected the verdict, it's error to grant a new trial. It has to have affected the verdict. There's no way it could have affected the verdict here.
Well, and once again, I'm sure Mr. Tinker is going to go into it. There's other evidence of other issues that happened, and the trial judge was in the best position to know what had happened up to that point. And his immediate response to the sidebar is, what are we going to do? This is a problem. This appears to be a mistrial. He's the one that's sitting there looking at the faces of the jurors. He knows what's going on in the courtroom. Why should we substitute our judgment for his?
Because if the defendant obviously did not think that a reference like that to insurance was really prejudicial. He was trying to pull a gotcha here after Dr. Mirabello had interjected, working for insurance companies into the case without any objection from or call for a sidebar or call for a curative instruction. If if the defendant did not think that Dr. Mirabello doing work for insurance companies and trying to justify his work by saying, hey, I work on plaintiff's side too once in a while. If the defendant himself as the advocate did not think that that was prejudicial, then it would be an abuse of discretion for the court to believe it was prejudicial. And I understand the issue, but the language from all the cases, even those that say it was not an abuse of discretion, they make it clear that to demonstrate prejudice is required. I'll move quickly to the other issue here. Well, first I'll address the argument in the brief that the record was insufficient because we didn't order the voir dire, the opening statement, the charge conference, or the instructions to the jury. And in none of those places could anything having to do with this alleged error have been important. All of the testimony was put in, all of the arguments concerning this issue was put in, so the court should reject that issue. I'll address quickly the argument and the
Weren't
answer.
there some questions about one issue on voir dire involving, I can't really tell you what it was about because I don't have it, but there were some questions in there about one of the witnesses and somebody having a friend who actually made it onto the jury. What can you enlighten us on that?
I'm sorry, I didn't quite understand the question.
My screen, sir.
Well, there was an objection, I think that was ruled on. There was some reference to a party who ended up having a friend who made the jury panel. Like I said, we don't have the benefit of the voir dire. We can let maybe Mr. Tinker add to that.
I'm sorry, Your Honor. I'm sorry. I didn't hear or don't understand the question. I apologize to the court.
You can move on.
Counsel makes a big deal about all of his other motions for mistrial that were denied, and he makes the argument almost like a tipsy coachman argument that the court should affirm because of all of these other things that happened during the trial. But there was no cross appeal on that, and the tipsy coachman doctrine does not apply when a court does not make discretionary calls. It only applies when there's a sufficient legal issue that would justify affirmance. So you can't affirm based upon those. And then what may be the key to the case, was this a new trial or was it a motion for mistrial that was granted before the jury was discharged? And the judge saying all day long after the jury is gone and after post-trial hearings are, I ruled, does not make it a ruling, no matter how much he says he ruled before trial.
Okay, so Mr. Watson, on that point, because I've gone back and I've read the transcript back and forth and read the sidebar conferences that they had. And so if the court, before the case went to the jury, was of the opinion that if the jury came down, if this was a plaintiff's verdict of any kind, then he was granting the mistrial. And I think that's pretty clear from the record. So if that's the case, then wouldn't it be that the moment the verdict came down for the plaintiff, that the motion for mistrial would have been granted and to follow through with the court's intent, and that therefore there would have been a granting of the motion before the discharge of the jury? I understand there's all this discussion after the fact, but if that was the clear intent of the court, can we not glean that from the record, that that's what the court wanted to happen?
That's what the court wanted. That's what the court wanted to happen, but it took more. It took a renewal of the motion. It took, when the verdict came back, the defense attorney needed to say, now, judge, you said you were going to grant me a mistrial, please do it. And that did not happen. And instead,
You're saying, okay, so let me be clear. So you're saying that the renewed motion for mistrial did not happen until after the jury left.
The motion happened, but the ruling didn't happen. The motion happened, but the ruling didn't happen. And I'll direct the court, and you know, the judge could say, yes, I meant to do it. And one case that the court should consider is the case of Granada Gardens versus Castro, cited in my brief. The site is 175 Southern 3rd, page 308. It's the 3rd district case where a court cannot turn a grant of a new trial after the jury is discharged into a mistrial nunc pro tunc. The ruling has to be made before the jury is discharged. And of course, in all these cases, the motion is first made before the verdict, and then it's renewed after the verdict. And in that case, being renewed after the verdict and then expressly granted after the jury is discharged, nunc pro tunc, is not sufficient. The intent does not matter. It has to be a ruling. And next, to the extent, even if you say it was a ruling, I grant a mistrial subject to.
Mr. Watson, just to let you know, you're coming up on your 5 minutes rebuttal time. You can continue if you want, but if you want to reserve it all, you need to wind it down.
I have a quick question before you leave us there. On this point, didn't the judge say, I want the transcript, the entire transcript of my order of the conference, and that is my ruling? I was trying to find the exact word, but isn't that basically what he said at that point?
Yes, he said that is my ruling, or he said, or even if he said that was my ruling, but it wasn't. Even if he said that's what I ruled, he didn't. It has to appear on the record, and if he meant to do it, but let me direct.
He also said, "Well, I basically entered it."
Well,
right?
I'm sorry.
He said, did he not use the words, "Well, I basically entered it"?
He said he did. He said he did, but he didn't. The record speaks for itself. He didn't do it. And in fact, I'll direct the court to page 45 of my brief, where I cite from pages 981, 982 of the transcript, where the motion was renewed after the verdict, and the judge said, all right, he gave two alternatives, what he was going to do. What I think I'm going to do is we're going to let the case continue. And then he said there's two alternatives. Real quick, I don't want to use up all my time, but I'm going to pull the reply brief here where I have that to say about it. On page 982, he said there's two things we can do here. He said, if the law shows it is really my granting the mistrial after the verdict, then that's what the judgment will say. If the judgment notwithstanding the verdict because of XYZ, then that's what the forum will say. So he already said after the verdict that he hadn't granted the mistrial because he said the two choices are it's either a mistrial after the verdict or a new trial, and he didn't grant it until the jury was gone. So it's a new trial after the jury was let go. This case shouldn't be tried again. It would be just a travesty, a waste of everybody's time and effort, and the verdict should be reinstated. Thank you.
All right, thank you, sir. Mr. Tinker.
Please the court. Good morning. Mark Tinker on behalf of McKinley Gulf of Mexico, also referenced in the record as Sail Point, as that is the name of this particular complex. This is quickly became one of my favorite cases because it's basically four different board certification questions wrapped into one case. The first issue is the one that you ended with, is the jurisdiction issue. Of course, we know what the rule is from Keene Brothers. If the mistrial was granted before the jury was discharged. You look like you're about to ask a question.
I am, because there's a part of Keene Brothers that says, and I want to tie this into this whole issue. They're referencing, the Florida Supreme Court is referencing its prior opinion in Severs versus McNulty, and the court says in McNulty, The trial judge took the mistrial motion under advisement and did not grant the motion until 5 days after the jury was discharged. Under those circumstances, we held that the motion for mistrial should be treated as a motion for new trial, thus making it a reviewable decision. Seems to me that doesn't the issue turn on when you discharge the jury? If you grant the motion for mistrial, by definition, you have to discharge the jury. That didn't happen, and therefore, once the jury has rendered its verdict and then been discharged, there's no longer a trial to have a mistrial over. The trial's over. So why shouldn't this be treated as a McNulty situation?
Well, I think it should be treated that way because what the judge made clear is that he did grant it prior to the discharge.
But he didn't, because here's where I'm driving at. If you grant a motion for mistrial, to grant it, you have to tell the jury, thank you for your service, go home. Right? In order for it to really be a grant of a mistrial, you're done with the trial. If indeed you have determined that there is an issue that there should be no, because that is the point of a motion for mistrial. The point of the motion for mistrial is we now have an issue that is so momentous and so dispositive. We're putting the brakes on this thing right now. We're stopping and not bothering this jury with any more service. And we're going to bring in a new jury.
And
Shouldn't there be a distinction between how a motion for mistrial is handled versus a motion for a new trial after the jury's reached a verdict?
I hear what you're saying, and I think that there is a distinction, but I think the two issues on this is first, the judge said, the parties actually agreed. We want to hear what the jury has to say. So the judge said, okay, we're going to hear what the jury has to say, but if it is a verdict for the plaintiff in any way, shape, or form, I'm granting the mistrial. I'm going to grant that motion. The verdict came back before the jury was discharged. It was renewed. I know there's a question about that. It's on transcript page 1026. It was renewed before the jury was discharged. And the judge at that point, as Judge Stargell mentioned, the judge said, what I'm going to do is I want to see your court reporter give me that transcript of the court conference from earlier today. That's going to be my ruling. So he's memorializing what he said earlier in the day, which is, this is a no-no, I'm granting the mistrial.
Mr. Tinker, explain to me the justification for why it should be that a judge reserves ruling on a motion for mistrial, then grants it, treats it nunc pro tunc, thus leading to an unreviewable ruling, versus simply stating, I will now entertain a motion for new trial based upon what was previously discussed as a motion for mistrial, in which instance it becomes a review order. I mean, explain to me what would be the justification for finding that fine distinction that this argument necessarily turns upon.
I don't know if there's a way to say that makes it as a justification, but the distinction is, what did the judge do? Did he make a ruling before discharging the jury or not? And it can be after the verdict. And that's what Keene Brothers said. It looked at, was the test the rendition of a verdict or the discharge of the jury? And Keene Brothers, the Supreme Court said, no, the verdict doesn't matter. You can do it post-verdict as long as the jury hasn't been discharged. So the Supreme Court's already recognized that distinction, that you can hear the verdict first.
Did the judge actually grant relief? Let's try that tack. Was relief actually given on the merits of the motion before or after the jury had been discharged?
It was granted before the jury was discharged. It was memorialized in writing after.
No. When was the relief? What is the relief for a motion for mistrial? What is the relief that the movement would get? It would be to stop the trial, right?
And once the verdict has come in and the judge says, if this is a verdict for plaintiff, I'm granting the mistrial. The verdict comes in, verdict for plaintiff, the judge grants the mistrial. There is no, that is stopping the trial. The result is to send the jury home, whether it's thank you for your service, go home, or there's been a mistrial, thank you for your service, go home. The jury doesn't know that. At that point, there is nothing else to do. So the judge says, if it's this verdict, I'm granting the mistrial. It was that verdict. So he said, give me my ruling from earlier today. That's going to be my order. And then he subsequently entered the order telling everyone what his intent was.
And Mr. Tinker, I guess that's the issue that I have is, okay, so what was the ruling from the court, right, before the verdict came in? I think that's what's so troubling here. It's really not clear. The court goes back and forth. Okay, I'm going to do this. No, I'm going to do that. No. Let's do this. And then they ask for a memo to be submitted. Well, that sounds good too. So the court was all over the map, but the one thing is clear, that the case went forward. And so, as you know, a trial court can change their position at any time. And there's cases on motions for new trial that there has to be a definitive ruling. And the ruling that we have here, unfortunately, doesn't come about until after the jury is discharged. And so the question I have for you is, the court could have easily changed its mind after, because the ruling hadn't come yet, right?
Correct. And I think what you're getting
But
at.
isn't that the problem that you have here?
No, I don't believe so. The court could have changed his mind. And I think the big confusion, and I agree with you, certainly this went back and forth and the transcript gets confusing because people started referring to it as a JNOV, which makes no sense in any context. So it got confusing as to what was occurring, but the judge at several points did make clear in no way is there a waiver of mistrial by us going forward. He said that repeatedly, you're not waiving this. We're going to hear what the verdict is. If it's a verdict for the plaintiff in any way, shape, or form, it's a mistrial. And then after the verdict came back for the plaintiff, he asked for the ruling from prior in the day. And he said, I believe Judge Startle, you quoted this. He said, well, I already granted it. I previously granted it.
But he couldn't have granted it because we had a verdict.
Well, his previous ruling
And I
was,
think, well, think about it. I know you know this to be true. So if he granted it, we wouldn't even be here talking about what he did. So I guess I have some issues too, because I see that appellate counsel was contacted during the middle of trial and all of this. And so I see where certain rulings were wanting to be had a certain way. You know, I don't know if the goal was to make sure in the end it was going to be non-final for the purposes of appeal, but I have some concerns over that. And so if that were the case, then why was there not this definitive ruling? And you can't mistake the fact that it comes after the jury is discharged.
the definitive ruling made before the jury, before the verdict even, was if there is a verdict for the plaintiff, it's a mistrial.
If, okay, and now you preface it with if, Mr. Tinker, you cannot, that is not a definitive ruling. Because the judge, like you've conceded, the judge can change their mind at any time. You know, just because, hey, I think I'm going to do this. Well, the judge has heard the rest of the evidence, you know, and then the juries come in, the verdicts come in, and the judge could say, you know what I said before, out the window.
The judge can, but he didn't. We know this on this record, in this case, we know that he didn't. He said,
well, after the fact. Well, that's the unfortunate thing, is after the jury was discharged.
Well, before the jury was discharged, he acknowledged that the renewed motion, and he said, get me the transcript from earlier in the day. So yes, it was.
Then that's the question I have for you. Because he says, give me the transcript. That was my ruling. But when you go back, it's a contingency ruling. And do you have any case law or anything that shows, I mean, it's almost like a springing clause. If this happens, then that will be, but he wasn't real definitive there. So we're really looking to him for what his intent was and what the words of the record was. So what can you point to in the law, either prior case law, to show us that that is something that a trial judge can do?
I'm not aware of any cases that talk about a contingency ruling like that. And I agree with you. That's probably the best way to label this. Is he said, if there's a verdict, that's my ruling. There was the verdict and that was his ruling. So the only thing that we can look at in this case, I know you said, can we infer that that was his intent? In this case, we don't have to. He entered 2 written orders afterwards explaining exactly what his intent was. So this is a different situation because we're not just stuck with his language where we're arguing to this court, what do you think the judge meant? What do you think his intent was? He told us after the trial in 2 different orders that these were not counsel drafted orders that he signed. These were his own orders. That's shown in the record that he drafted these. He cited Keene Brothers in the first one, letting the court know that he's very well aware of the significance of what he's doing. He knows the before and after discharge of the jury test. And he said, I granted it before. There was a motion for reconsideration of that, and he expressly stated the second time that this ruling was made before the discharge of the jury. I granted a mistrial.
Try this, Mr. Tinker. What is the justification? Why is it that we hold that granted motions for mistrial are not reviewable?
Because if a mistrial is granted, there never was a trial. It never went to conclusion. And at this point, and again, the Supreme Court has said that can happen after verdict. So we know between a verdict and the discharge of the jury, that can still happen. And that's what this judge did. After the verdict, we've been calling it the contingency, the verdict triggered the contingency. And so he granted it, and he let us know with his written orders that that is what I did.
Okay, so Mr. Tinker, this argument. So let me say a motion for new trial or mistrial is raised, and the judge says, I deny it. I'm never going to consider it again. Okay, and so then the verdict comes down and it's opposite what they thought. And so the judge says, I'm granting the mistrial. Doesn't the judge have the discretion to do that?
The judge does.
Judge changed its mind, but no, Judge, you said you promised beforehand you would never consider another motion for mistrial or even this exact very motion for mistrial. I mean, isn't that kind of what you're arguing here? I mean, that's being argued.
Well, your question is, can the judge change his mind? And
Absolutely.
The judge can, but he didn't in this case. So on this record, in this case, we know he didn't.
But I think no, he did. So I understand what you're saying, but the point is that the judge could. And so the fact that the judge makes promises ahead of time in that there's a contingency gives this doesn't fit in the line of cases where there's a definitive ruling on a motion for new trial, which is what we have to look at. And I just don't see it.
I understand. And I think, I agree with you. I think if it had been definitive before, if it wasn't contingent on this verdict, everyone would have packed up their bags and gone home. This was contingent on the verdict. It went to the verdict, and in between the verdict and the discharge, the judge said, I need to see my ruling from earlier.
And I agree with you to one point that I think the judge could have made a contingent ruling if he had a stipulation by every counsel. But in this case, there was by no means any stipulation between everybody because no one could even agree what the ruling was.
And I agree with that. And I think in this case, it's sort of, I don't want to repeat myself, but I think it comes down to when the verdict did come in, that's when the judge made clear what his ruling was. He asked for the prior transcript from earlier in the day, and then post-trial, he issued the 2 written orders saying this was what I did. I know we've used a lot of time on that, and I hope, and if the court has any other questions, I'm certain to, I'll be happy to continue addressing them. But I would like to say, if we are considering this an order granting a new trial, there are 2 main issues with that that came up in the argument earlier by Mr. Wasson. And then first is the preservation issue with the incomplete transcript. We're missing voir dire, we're missing jury selection, we're missing opening statements, charge conference, but the first 3 that I mentioned are the important ones. This is a judge who's decided that he's granting a mistrial, new trial, whatever it might be, based on improper comments. And I guess I need to backtrack first. The comments that were made, I know Mr. Wasson said, well, this isn't liability insurance, so it shouldn't matter. This wasn't about insurance. This was about implying to the jury that Ms. Harvey did not have health insurance like the rest of us do. That's why, the rest of us wouldn't appreciate how expensive her bills are. Throughout the trial, and I've cited them in my brief, there were references to McKinley being such a big company that were objected in their motion for mistrial that was denied on that. There are references to the fact that it owns multiple properties, not just SailPoint that we mentioned, but there are other apartment complexes. So it's a big company. There are references to how much Ms. Harvey pays. There are questions about how much she pays in rent that was received an objection, and also how many units are in this complex. We know how much money they're bringing in.
And Mr. Tinker, and so I did have a question on the prejudicial aspect of it. And so when the objection, so we have the testimony of the expert ahead of time that mentions insurance. There's no objection. Then we have the event here, which is the insurance, the no-no, the trial judge calls it. And so at that point in time, when the motion for mistrial is argued. Are all of these things that you're raising now as far as prejudice, were they before the court when the court ruled?
The evidence, the prior motion for mistrial on McKinley being a big company, the objections to
The sympathy to the plaintiff, was that argued at the time?
nothing was
No, I
argued
didn't
at the
think,
time. There was
right, I
the-
didn't think so. It was just like, oh my gosh, I heard insurance and that's a no-no and we, you know.
And that's
So,
where I'll, I guess, circle back to where I started with this is the judge is viewing this in the entire context of everything that Judge Siraka has heard throughout the past several days before that. A lot of that we don't know. Now, I know Mr. Watson's saying nothing important happened in voir dire, nothing important happened in opening. And
well, help me out. So did any of the prejudice that you're arguing now, was that before the court rang the bell and said no?
Yes.
All of it or which part?
The court rang the bell in closing arguments.
No.
All of it.
I know. Okay.
So
Okay.
everything that I've cited was already previously before the court, all the prior motions for mistrial and
But
objection.
were any of the sympathy arguments made to the court before that? Like
Yes.
in other objections? I guess that's a better way to ask my question.
Yes, Your Honor.
Okay.
When there was the reference to McKinley, it was actually the first witness. It was the third question of the first witness. Was McKinley is a big company, isn't it? And there was an objection, motion for mistrial based on wealth. versus
Right, I remember
poverty
reading that.
denied
Okay.
Right there. I mean, that was the
Okay.
third question of the first witness. There was an objection when there was a question about how much Ms. Harvey pays in rent and how many units are in this facility. There was an objection there that was
Okay.
sustained as well. There were several issues throughout the case, and there are things that weren't necessarily objectionable, but that led into this, such as both Ms. Harvey and her husband Chaz on this record testifying, we're here because we need to get our medical bills paid. We have all of these bills. Ms. Harvey testified, I'm treating under letters of protection, which means my doctors don't get paid unless you give me money in this lawsuit. You know, the jury knows that. The jury asked a question. It submitted a written question saying, are we allowed to know if she has health insurance and whether it paid her bills?
Right.
So the jury has this concern already. The parties agreed they can't know that. Both Harvey's trial counsel and SailPoint's trial counsel, everybody agreed that's improper. We know this is improper. And that's exactly what the issue on closing argument was, a reference to, well, those of us who do have health insurance don't realize how expensive this is. Ms. Harvey does. She needs this lawsuit to get her bills paid. So all of that was before the court. He'd heard all of that. And again, he heard things that this court didn't hear. And his order comes here with a presumption of correctness. As you know, it's an abuse of discretion standard. You have to decide no reasonable trial judge could have done what Judge Siraka did, but you don't know what he heard. We don't know, and I'm going to make stuff up because I didn't see it either. We don't know if during voir dire, there was an entire exchange that happened about, we think big corporations have all the money and whenever somebody's injured on a property, they should get paid. And maybe there were cost challenges that happened. Maybe during opening statement, there was an objection, a motion for mistrial that we don't know about. I'm just saying, I'm making things up because we don't know. I haven't seen the transcript and neither has anyone on this court. Now, Mr. Wasson, of course, he says nothing important happened there. He's saying that as an advocate who also says that this closing argument wasn't important, that the references made to a big company wasn't important. That's an advocate speaking. The fact is, we don't know what Judge Siraka heard. And in the moment he heard this, as I think to go to your question, Judge Smith, there was no argument to be entertained. He immediately said, that's a no-no. That's not good. Everything he heard that this court hasn't been able to see went up to him making that ruling in that moment. And so that there's a lack of preservation with not providing this court with the entire record. It doesn't have the ability to assess whether he used his discretion in making that ruling.
Mr. Tinker, just to let you know, you're coming right up on 20 minutes.
Okay. The only other issue I'd raise, I know I raised the tipsy coachman type arguments. There was the argument made, there's no cross appeal. This is why at the beginning I said this would be a great board certification test. In federal court, that would have had to have been a cross appeal. In state court, I don't believe it is because I'm not asking for any affirmative relief. A cross appeal is if I'm asking you to do something different than what the order says. If we are here assuming this is an order granting a new trial, I want that affirmed. That can be affirmed on any basis evident in the record. I think especially the Binger violation with respect to the treating orthopedic surgeon that came up with a new opinion mid-trial based on records he's provided mid-trial. That's a clear Binger violation. It was overruled. He was allowed to provide the opinions. The verdict shows, based on the evidence, that his opinions went into that verdict. There's no other way for the jury to arrive at those future medical expense numbers without accepting it. So
All right.
I see you're about to cut me off, Judge.
Yeah.
So with all that, I just ask that the court affirm. Thank you for your time.
Thank you, Mr. Tinker. Mr. Watson.
Here's why nothing important could have happened during those parts of the transcript, because those parts, I guess he's suggesting now, Mr. Tinker's suggesting that there might be stuff about financial disparity or something. The motion for mistrial that we're here about today was only about insurance. That's the only issue. There could, if there was anything said in those other parts of the transcript about financial disparity, that couldn't tie in with the motion for mistrial that was made, because trial counsel never argued to the judge, as Judge Smith was saying a few minutes ago, this is not about insurance, it's about financial disparity, and think of what happened earlier, blah, blah, blah. I didn't address, and to go back to the question in my initial argument, about what counsel's argument about what happened in voir dire about a prospective juror that had been discussed. He raises this in the context of an unpreserved complaint about something. He doesn't cross appeal, as I said, even if you don't need to cross appeal to raise tipsy coachman. The tipsy coachman doctrine does not apply to warrant affirmance on discretionary calls. You can't say because the judge would have had the discretion to grant a mistrial on these other grounds, even though I didn't appeal the denial of it, the verdict should
It's okay,
be.
Mr. Watson. I was just responding to you saying there was nothing in that part of the transcript. You can move on to your other issue. In fact, I have a question following up on the jury's question about insurance, because that was what was particularly intriguing to me. The fact that this judge had already had the jury have a keen interest in, does this person have insurance? And then the statement in closing is, we know particularly in this case, the cost of medical care is more expensive than we really think. If we have health insurance, we don't really. So, you know, I appreciate it. He goes on, you know, somewhere in there is where they cut him off. Isn't the trial judge in the best position at that point to see what's going on? You know, moving past whether he actually ruled for the mistrial there or whether he's granting a new trial, isn't he in the best position to know, in looking at this, whether that statement coupled with the other evidence, the question that was asked and everything else, whether a new trial should be granted?
I respectfully disagree. Don't think so, because you know, the jury was given such a cautionary instruction when they asked that question about is there insurance? Insurance has nothing to do with this case. It's not a matter of concern. So they couldn't glean yes or no from that. And they couldn't glean yes or no that she had insurance from counsel's closing argument about the cost of medical bills, whether she had insurance or not from that. It's a reference to insurance, but it doesn't convey necessarily that she lacked health insurance. And again, the argument was not made, Judge, I want a mistrial because of financial disparity. It was only because of the reference to insurance. That's not enough in the many cases that say isolated reference can be cured by curative instructions.
What he's saying is, if we have health insurance, we don't know the cost. We don't really know because we don't see it. But the jury's heard all of this evidence of her and her husband saying what a hardship this is on them. So there's an inference there that, you know, hey, we're on one side because we have health insurance. What's your response to that? How could the jury possibly not have been seeing this as the answer to their question?
Well, I think again that's a financial disparity argument, and the motion for mistrial was not made on the grounds that comment promoted financial disparity. It was only the magic word insurance. it's an end all case, case dispositive, no matter what the financial circumstances of the parties are. So I don't think the argument was made there in the motion for mistrial. So to the point that their jury may have been considering some financial disparity, I don't think that demonstrates any prejudice. There was no prejudice. This was a well thought out, hard fought trial. There's no prejudice. It was cured by a curative instruction, and the verdict should be reinstated. The judgment should be in. Thank you very much.
Thank you both. Ask that you please exit the
Very
virtual
interesting case.
courtroom at this time. And we'll call our next case on the morning's docket, which is Precision Orthopedics, Inc. versus Zimmer US, Inc.